Okay, proceed.
Yeah. Good morning, everybody. I, Manoj Kumar Chaudhary, welcome you all on behalf of Nani Palkiwala Law Club. As we know, our three laws of the criminal, that is IPC, CRPC, and Indian Evidence Act has changed. And we got a consent from the President on 25th December 2023, and the Act has been enacted from the 1st of July 2024. Today, we are here to continue our part 2 of the BNS, which we have covered up to the section 125. So today we have Advocate Jayprakash Somani from Supreme Court of India to give a details about the differences between the BNS and the IPC. Over to you, sir.
Thank you. Thank you, Manoj. Friends, in last part, we have seen up to article 125 of BNS, and we compare that article 125 of BNS to section 125 of BNS to section 338 of IPC. I'm sharing you. Let me share the document. Just give me a few seconds. I hope you have watched that webinar on YouTube also, because it is live on YouTube. Earlier episode was also on YouTube. New IPC, CRPC, BNS, IPC comparative. Yes. Yes. So friends, I'm going on page number 1, section number 125. See, 110.25 we already completed in part 1. In part 2, we'll start from of wrongful restraint and wrongful confinement. In BNS section 126, wrongful restraint change, and its corresponding section was in IPC 339 and 334 of IPC, punishment for wrongful restraint. It is now in BNS 126 subclause 2. So wrongful restraint is in section 126 now in BNS. BNS section 127, wrongful confinement. So 127, 127, 1, 127, 2, 127, 3, 127, 4, and 127, 5, 127, 6, 127, 7, and 127, 8. So earlier, this section was a separate section in IPC. So in IPC, 127.1 was 340 wrongful confinement. 127.2 of BNS was 342 section punishment for wrongful confinement. 127.3 of BNS was 343 wrongful confinement for 3 or more days. BNS 127.4 was in IPC 344 wrongful confinement for 10 or more days. BNS 127.5 was in IPC 345 section wrongful confinement of person for whose liberation right has been issued. Section 127.6 of BNS is corresponding section in IPC was 346 wrongful confinement in secret. 127.7 was in IPC 347 wrongful confinement to extort property or constraint to illegal act. Then section 127.8 of BNS is corresponding section in IPC was 348 wrongful confinement to extort confession or compel restoration of property. Now of criminal force or assault. In BNS section 125 is for force. Its corresponding section in IPC was 349. In BNS 129 section is related to criminal force. It was 350 section criminal force in IPC. In BNS section 130 assault, its corresponding section was in IPC 351 assault. In BNS 131 section is related to punishment for assault or criminal force otherwise than on grave provocation. Its corresponding section was 352 in IPC. In BNS section 132 or 132 assault or criminal force to deter public servant from discharge of his duty. Its corresponding section was in IPC 353. In BNS section 133, assault or criminal force with intent to dishonor person otherwise than to grave provocation. In IPC, that section was 355. In BNS section 134, assault or criminal force in attempt to commit theft of property carried by a person, corresponding section was 356 in IPC. In BNS section 135, assault or criminal force in attempt to wrongfully to confine a person, its corresponding section was IPC 357. In BNS section 136, assault or criminal force on grave provocation change, corresponding section was 358 in IPC. Now we are going towards kidnapping, abduction, slavery, and forced labor. Now, kidnapping 137, kidnapping corresponding was in IPC 359. 137.1 in BNS, kidnapping from India. Its corresponding section was in IPC 360. 137.1 subclause B in BNS is related to kidnapping from lawful guardianship. Corresponding section 361 was in IPC. In BNS 337.2 is related to punishment for kidnapping. Its corresponding section was in IPC 363. 138 of BNS abduction, corresponding section was in IPC 362. In BNS 139 section, kidnapping or maiming a child for purposes of begging, its corresponding section was in IPC 363A. In section 140 of BNS, kidnapping or abducting in order to murder or ransom, its corresponding section in IPC was 364. In BNS section 141, 142 is related to kidnapping for ransom. Its corresponding section was in IPC 364A. In BNS section 140, subclause 3 is related to kidnapping or abduction with intent secretly and wrongfully to confine person. In BNS section 140, subclause 4 is related to kidnapping or abducting in order to subject a person to grievous hurt, slavery. Its corresponding section was in IPC 367. In BNS section 141, importation of a girl or boy from foreign country, its corresponding section was in IPC 366B. In BNS section 142, wrongfully concealing or keeping in confinement, kidnapping or abducting person, its corresponding section was in IPC 368. In BNS section 143, trafficking of a person, its corresponding section was in IPC 370. In BNS section 144, exploitation of a trafficked person, its corresponding section was in IPC 370A. In BNS 147 section, habitual dealing in slaves, its corresponding section was in IPC 371. In BNS section 146, unlawful compulsory labor, its corresponding section was in BNS 374. Not in BNS, corresponding section in IPC was 374. Sorry for slip of tongue. Now, chapter 7 of offenses against the state in BNS chapter 7, but earlier the chapter was 6 in IPC, offense against state. In BNS section 147, wagging or attempting to wage war or abetting wagging of war against government of India, its corresponding section was 121 in IPC. In BNS section 148, conspiracy to commit offences punishable by section 147, its corresponding section was in IPC 121A. In BNS section 149, collecting arms etc. with intention of waging war against government of India, its corresponding section was in IPC 122. Why? This section are earlier in IPC then? Because of IPC was formed in the era of British government, 1860. So, British government have given more importance to the offences which is against their government. So, they have taken that section in earlier stage and they have given less importance to other offences. But when we replaced this law with Bharatiya Nyaya Sanhita, BNS, so we have given preference to the offences against woman first, then offences against man, woman, body, related to body offences, kidnapping, like that. And then later we are giving preference to the offences against the state. So British government has given focus to the offences which were against them at that time. So you are finding this section is earlier section in IPC as compared to BNS. Specifically, these offences against the state. So friends, section 150 of BNS, concealing with intent to facilitate, designed to wage war. Its corresponding section was in IPC 123. In BNS section 151, assaulting president, governor, etc. with intent to compel or restrain exercise of any lawful power. Its corresponding section was 124 in IPC. Sedition of IPC section 124A, now it is deleted. And new section added in BNS section 152, which was not in IPC. And that section 152 of BNS Act, endangering sovereignty, unity and integrity of India. So under this, when this law is applicable from 1st of July, you are now observing what type of action Indian Army is taking now against the terrorists of Jammu Kashmir area. See their action, because there is a separate power now. Acts endangering sovereignty, unity and integrity of India. Nobody can disturb the integrity of India because of BNS, this new section, section 152. But army and police should not use extra power, extraordinary, unreasonable power, which is against humanity, which is against human rights. That will cause unnecessary black image of our country also. So my court, Supreme Court, is perfect here, who will guide to government also, to army also, to police also, how to use this power. So friends, next, section 153 of BNS, waging war against government of any foreign state at peace with government of India. Its corresponding section was 125 in IPC. In BNS section 154, committing depredation or territories of foreign state at peace with government of India. Its corresponding section was in IPC 126. In BNS section 155, receiving property taken by war or depredation, mentioned in section 153 and 154 as above. Its corresponding section was in IPC 127. In BNS section 156, public servant voluntarily allowing prisoner of state or war of escape. Its corresponding section was 128 in IPC. In BNS section 157, public servant neglecting, suffering such prisoner to escape. Its corresponding section was in IPC 129. In BNS section 158, aiding escape of, rescuing or harboring such a prisoner. Its corresponding section was 130 in IPC. Friends, in this part 2, we will complete sections till 245. So we have to complete 245 section of BNS in part 2. And in part 3, I will conduct this on Zoom as well as on live on YouTube on coming Tuesday. At around 6 p.m. And I'm very happy to share you that in very near future, we are starting a separate series of lectures of eminent senior lawyer, like my friend Kapil Sibal, like my Kapil Harish Salve, my friends, so many, Dr. Abhishek Manu Sangvi, Jaydeep Gupta, so many senior lawyer, eminent lawyer of our country, retired judges of high courts, retired judges of Supreme Court. If current judges allowed, तो current judges का भी ले लेंगे. So उसका भी series हम start करेंगे. हफ्ते में एक बार या 15 दिन में एक बार हम वो लोगों को भी आपके सामने लाएंगे. Because I am from rural area, यार मुझे rural area में facility नहीं मिलती थी. I have completed my LLB in Ahmednagar. I don't get this facility in Maharashtra in Ahmednagar. I completed my last year in ILS Pune. ILS Pune have some different facilities. I have enjoyed that. But when I come from Bombay High Court practice to Supreme Court for Apex Court practice, then this is my wish. Whatever my friend, I'm getting this type of good friends. I am exchanging that knowledge with me. So same knowledge I want to spread to all legal fraternity of India, or law students also, all law lover persons also. So this is my target behind this. And Nani Palkiwala was my best guru. He taught so many things to us. So this club, national club, is on the name of my guru, Nani Palkiwala, who was the backbone of our keeping democracy through the doctrine of separation of power, doctrine of basic structure. Doctrine of basic structure is very important, which come from his very renowned leading case, Keshwananda Bharat. We'll speak on different subject, different time. Don't worry. I will give you so many things, so many laws, so many videos already are there in on YouTube channels. But I will try to give each and every law test to you, every custom law, foreign trade law, which ordinary you will not read it. You will read IPC, CRPC, CPC, like that, Constitution, if you are practicing in High Court or Supreme Court. But international laws, which is related to arbitration law, corporate law, you can find my one series on corporate law on my website, or go to my LinkedIn account. LinkedIn account, you will find my series. Every Puja, on every Tuesday we are posting that now. Every Tuesday we are posting that. 41 corporate laws we are covering in that. That is a block series. That is not a video series. But in future, same law we will take in one webinar, and I will explain you the section, content of that section, that law, and which are the important sections of that particular law as per the legal practice or as per the businessman also. Businessman, suppose if anybody is doing the export-import business, okay. So most important section is 11 of Custom Act for businessman also and for lawyer also. So what prohibited is given in section 11, and if anybody is infringing that section 1, then he have to face the penalty or imprisonment or punishment which is given under section 100 onwards in Custom Act. So total Custom Act is beautiful, but specifically which is a prohibited thing if we are doing that, so that is a different. So we will cover this. This is my hobby. और आप लोग जुड़ते हैं बहुत अच्छा मुझे कि अभी किसी एक दो के मैसेज आए तो बहुत अच्छा मुझे ये करते हैं, और ऐसे ही आप YouTube पे जाके भी वो उसको शेयर करो, आपके व्यूज शेयर करो हमारे. You can go to our Google My Business account also, on Google Map also, Jayprakash Somani Advocate, and you can put your views there also. That will get motivation to me. So friends, now chapter 8. in BNS of offences related to the Army, Navy, and Air Force. Its corresponding chapter was in IPC chapter 7. Now chapter 8, but in IPC chapter was 7. In section 159 of BNS, abetting mutiny or attempting to reduce a soldier, sailor, or airman from his duty. Corresponding section in IPC was 131. In BNS section 160, abatement of mutiny, if mutiny is committed in consequence thereof. Its corresponding section was 132 in IPC. In section 161 of BNS, abatement of such assault if assault committed. Its corresponding section was 134. Abatement of such assault if assault committed. In BNS section 163, abatement of desertion of soldier, sailor, or airman. Its corresponding section was IPC 135. In BNS section 164, harboring deserter. Corresponding section was in IPC 136, harboring deserter. In BNS section 165, deserter concealed on board merchant vessel through negligence of master. These are the special cases. No? These are special cases. Bombay High Court, Chennai High Court, Kolkata High Court. You can enjoy such type of cases there. It is from obviously from session court, then after session court to trial court. And if army related matter, then first this trial is going to martial court there, and after martial court appeal can be to AFT, Army Armed Forces Tribunal, and after Armed Forces Tribunal direct as per section 30 and 31 of AFT Act, it comes to the my court, Supreme Court, like that. Section 166 of BNS, abatement of act of insubordination by soldier, sailor, or airman. Insubordination by sailor, abatement of act of insubordination by sailor, soldier, sailor, or airman. Its earlier section in IPC was 138. In section 167 of BNS, persons subject to certain acts. Earlier section 139 in IPC. In BNS section 168, wearing, grab, or carrying token used by soldier, sailor, or airman. Earlier section was 140 in IPC. Now chapter 9 of offences related to elections. Earlier the chapter was chapter 9A of offences related to election in IPC. In BNS section 169, candidate electoral right defined. Earlier section 171A of IPC. In section 170, bribery in BNS. Earlier section was 171B for bribery in IPC. Now see, these sections are very near in BNS also, and as well as in IPC also. In section 171 of BNS, undue influence at elections. Its corresponding section was in IPC 171C. In BNS section 172, personation of at elections, corresponding section was in BNS 171D. In section 170C 73 of BNS, punishment of bribery. Corresponding section was in IPC 171E. मैं कभी कभी ऐसा पॉज हो जाता हूँ ना, तो वो थोड़ा दिमाग भटकता है, इधर उधर कुछ एक अलग याद आता है, और I'm wishing to tell you that, but due to time constraint, I have to stop that by emotion. So somewhere you are finding I'm pausing that like that, but forgive for that. In section 174, punishment for undue influence or personation at an election, corresponding section was in IPC 171F. In section 175 in BNS, false statement in connection with an election, corresponding section was 171G. So, friends, study this section properly, and at the time of election, guide your leaders about these sections. And whenever your leader's opposite leader is infringing this section, so fatapat litigation can be started. I'm not promoting the litigations, okay, but when they are crossing their limit, to speaking of false statement now, so they should get punishment. They should get at least a punishment related to fine also. So these cases should be there in the court. FIR should be registered against them by using these sections. So when then our election will be very on the focused on only development, not gali galoj karo, ye karo, wo karo, giving false statement like that. So this is not good thing. So this is our duty as a lawyer, friends. We are the backbone of our democracy. Bench and bar, both judges and lawyer, are the two parts of the same coin. I know some judges are also in Nani Palkiwala National Law Club, but judges and advocates are the backbone of our democracy. Whenever state or union is doing a wrong thing, we are there to control them. So we are in very noble profession, friends. But when we have the noble profession, we have the responsibility also. So we should not use this for personal benefits. We should use for the social benefits like that. Section 175, false statement in connection with an election. We already completed that. 176 section of BNS, illegal payment in connection with an election. Earlier section was in IPC 171H. BNS section 177, failure to keep election accounts. Its corresponding section was 171I. Chapter 10 of BNS is related to offences related to coin, currency note, bank notes, and government stamps. Its current corresponding section was chapter 12 in IPC. Now BNS chapter 10, and it was chapter 12 in IPC. In BNS section 178, counterfeiting coin, government stamps, currency note or bank notes. Counterfeiting means duplicate karna, forgery karna, like that. Its corresponding section was 231, counterfeiting coin, and 255, counterfeiting government stamps, and 489A, counterfeiting currency notes or bank notes in IPC. Explanation. 178.1, explanation to section 189A in IPC. In BNS section 178.2 is related to definition of coin. Earlier section was 30 in IPC. In BNS section 178(3), explanation to 255 in IPC. 178(4), explanation to corresponding section was in IPC 231. In BNS section 178(5), corresponding section 246, fraudulently or dishonestly diminishing weight or altering composition of coin. 148, altering appearances of coin with intent that it shall pass an coin of different description. Reference to Indian coin remove. Now in BNS 179, using a genuine, forged or counterfeit coin, government stamp, currency notes or banknotes. I will share you some of my thoughts related to the crimes, related to our legal system, related to our police system at the end of this session. So we will all share document, then I will share you some of my thoughts. In section 179 of BNS, using a genuine, forged or counterfeit coin, government stamp, currency notes or bank notes, its corresponding section was in IPC 237, 238, 239, 240, 241, 250, 251, 254, 258 and 260 and 489p. In BNS section 180, possession of forged or counterfeit coin, government stamp, currency note or bank notes. Its corresponding section was in IPC 242, 243, 252, 253, 259, 489C. Section 181 of BNS, making or possessing instruments or material of forging or counterfeiting coin, government stamp, currency notes or bank notes. Its corresponding section was 233, 234, 235, 256, 257, 489D in IPC. One section which is not now in BNS, it is deleted from BNS, but it was in IPC, that section 236 section of IPC, abetting in India the counterfeiting out of India of coin, out of India of coins. Now section 182, making or using document resembling currency notes or bank notes. Its corresponding section was 489E in IPC. Friends, section 183 of BNS, appacing writing from substance bearing government stamp or removing from the document a stamp using for it with intent to cause a loss to the government. Its corresponding section was 261 in IPC. Section 184 of BNS, using government stamp known to have been before used. Corresponding section was IPC 262. In BNS section 185, ensure of mark denoting that stamp has been used. Corresponding section was in IPC 263. In BNS section 186, prohibition of fictitious stamp. Corresponding section 263A, prohibition of fictitious stamp. In BNS section 187, persons employed in mint causing coin to be of different weight or composition from that fixed by the law. Corresponding section was in IPC 244. In BNS section 188, unlawfully taking coining instrument from mint. Those who are working in mint. Mint means where these coins are prepared. That is called mint. So if a mint employees specifically are doing such type of offense, so that cover in section 187 of BNS, person employed in mint causing coin to be of different weight or composition from that fixed law, and also unlawfully taking coining instrument from the mint. Section 188. Its corresponding section was 245 in IPC. Now chapter 11 of offences against the public tranquility. Its corresponding chapter was in IPC chapter 8 of offences against the public tranquility. Unlawful assembly. Section 189 of BNS is speaking about unlawful assembly. Corresponding section of IPC was 141. Now section 189(1) is related to unlawful assembly. 189(2) is punishment. 189(3) is joining or continuing in unlawful assembly, knowing it has been commanded to disparate. Earlier section was in IPC 144, 145. In BNS section 189(4), joining unlawful assembly armed with deadly weapons. Corresponding section was an IPC 144. In BNS section 189(5), knowingly joining or continuing in assembly of 5 or more persons after it has been commanded to disparate. Corresponding section was in IPC 151. In BNS 189, section 189(6), hiring or convening at hiring of a person to join unlawful assembly. Corresponding section was 150 in IPC. In BNS section 189(7), carefully go through these sections. This is related to public safety, public peace, assembly like that. Unlawful assembly, we have to control that. That unlawful assembly may be against the government, unlawful assembly may be against the any particular person also. So as a lawyer, it is our duty to impose proper section properly. Police are also well trained now, because earlier police was very less qualified, but now graduate, postgraduate students are also coming in police department. So this is very good thing for our country. Educated people are coming there, and they are doing their duty very honestly also. Many police officers are doing their duty honestly. Exceptions may be there. Section 189(8), being hired to take part in an unlawful assembly or riot. Corresponding section was in IPC 158. 189(9) or to go on, section 158 of IPC. 190 of BNS, every member of unlawful assembly guilty of offence committed in prosecution of a common object. Its corresponding section was 149. 191 is related to rioting. Earlier section was in IPC 146. Section 191(1), Section 191(2) of BNS is related to punishment of reorting. Earlier section 147 in IPC. Section 191(3) of BNS, reorting armed with deadly weapons. Earlier section was in IPC 148. Section 192, wantonly giving provocation with intent to cause reort if reorting be committed, if not committed. Earlier section in IPC was 153. Section 193 of BNS, liability of owner, occupier, etc. of land on which an unlawful assembly or reort take place. See how law is best law. So landowner should be take care. The unlawful assembly should not be stand on their land. Owner or occupier of land on which an unlawful assembly is held. Earlier section was 154. Section 193(2) of BNS is related to liability of a person for whose benefit reorting is committed. Earlier section was 155. Section 193, subsection 3, liability of agent of owner or occupier for whose benefit reort is committed. Section 194 of BNS, affray. Earlier section was 159. Section 194(2) of BNS, punishment for committing affray. Section 195 of BNS, assaulting or obstructing public servant when suppressing reort, etc. Earlier section in BSN, in IPC was 152. In section 196 of BNS, promoting enmity between different groups on ground of religion, race, place of birth, residence, language, etc., and doing act prejudicial to maintenance of harmony. Earlier section was 153A. Now 153AA is deleted. IPC's 153AA is not in BNS. What is 153AA of IPC? Punishment for knowingly carrying arm in any prosecution, in procession, or organizing or holding or taking part in any mass drill or mass training with arms. Cooling bada. Section 197 of BNS, computation, assertion, prejudicial or to national integration. Earlier section was 153B. Now chapter 12 of offences by or related to public servant. How this chapter is compared to IPC's chapter 9. Now it is chapter 12 of offences by or related to the public servant. Friends, I also, you also, when we are sitting and when reading law, when it matter is related to our case, we are giving so much time and we are completing drafting, we are completing study for argument, everything. Okay, then we can sit 3 hours, 4 hours. But apart from our regular cases, just for the sake of knowledge or sake of revision when we read law, we are not giving such much more time on that. We are giving only half hour or 1 hour that. But due to such type of seminars or webinars, we can cover that. And whenever you want to repeat it again at your leisure time, you can play this video on YouTube and you can watch that again. So this is the benefit of YouTube also laterally. And I'm appealing you for law schools or bar associations. If law schools or bar associations want to conduct this my program lively, near about Delhi, nearby Delhi, I can give this program lively also. I will come to your bar association, I will come to your law school, and full day we can give to BNS compared to IPC, full day. And section after 40, we can explain some sections also in that. And full day, like a full day workshop. It start from 9 a.m. With breakfast. Then near about 11 a.m. light break for a tea. Then around 1 p.m. there will be a break for lunch. Then again program will start until evening. We can complete entire BNS with compared to IPC. And if you organize this for 2 days, then we will complete BNSS also compared to CRPC. So into you have the chance to organize my both program or any one program. Yeah, I will not take any professional fee for that. Just my going, coming, and residential expenses, whatever may be. You can do that. But I would like to, because after so many presentations, so automatically I will also get benefited of that. Now section chapter 12 of offenses of or by or related to public servant. See here, offenses by or related to the public servant. If a public servant is doing some offenses, that is also covered here. And offenses against public servant is there, that also covered here. Section 198 of BNS, public servant disobeying law with intent to cause injury to any person. Its corresponding section was in IPC 166. Section 199 of BNS, public servant disobeying direction under law. Corresponding section was in IPC 166A. Section 200 of BNS, punishment for non-treatment of victim. Corresponding section was 166B. Police also public servant. So punishment for non-treatment of victim. So victim treatment should be there. But this is not only against the police. This is against any public servant. Government hospital, government doctors are public servant. So if you go in depth, that time you will find the real knowledge of that particular practical application of that law. Law in BNS Act is a different. When practically we apply that law, that is a beautiful when we are reading the judgment. This is my recommendation to all the lawyers. Before going on bed in the night, you should read at least one judgment of High Court or Supreme. If you are practicing trial court or High Court, you read one High Court judgment or any Supreme Court. But if you are practicing in Apex Court, Supreme Court, before going to bed, at least read one judgment. For the sake of that, I have published more than 60 books on that, Supreme Court case laws. Each book contains 21 cases. So easily you can read one and one, two pages. What exactly practical application of that particular sections, particular law is there? Through the wisdom of my Supreme Court judges. They are very wise, very wise. Each and every judges are very wise in Supreme. So I dedicated my each and every book to the Supreme Court's past, present, and future judges. If you read that page particular in my books. So friends, we have to go in depth to read the practical applicability by reading the judgment. That should be in a habit. And that is the art, how to read the judgment in short. You will find some of my courses on my app. If you go on Android, Jayprakash Somani app, so you will find some courses, how to argue in High Court, in Supreme Court in English, how to draft SLP, how to, some pre-recorded courses are there. You can buy that courses, you can use that courses, and all videos are with you for 2 years in that courses. And you can contact to my PA Pooja Rai. She will give you a beautiful discount also if you contact her. Her name, her number you will find in the description. After uploading this particular video on YouTube. So friends, section 202, public servant unlawfully engaged in trade. 201, public servant framing an incorrect document with intent to cause injury. This is a BNS section 201, but its corresponding section was in IPC 167. Section 202 of BNS, public servant unlawfully engaging in trade. Its corresponding section in IPC was 168. In BNS section 203, public servant unlawfully buying or bidding for property. Its corresponding section was 169. Section 204, personating a public servant. Corresponding section was 170, personating a public servant. Section 205, wearing crab or carrying token used by public servant with fraudulent intent. Its corresponding section was 171. Chapter 13 of BNS of contempt of lawful authority of public servant. Earlier, the chapter was 10, contempt of unlawful authority of public servant. When we are not obeying public servant, when we are not following the public servant, contempt, we are doing the contempt. In section 206 of BNS, absconding to avoid services of summons or other proceedings. So corresponding section was in IPC 172. In BNS section 207, preventing service of summons or other proceedings or preventing publication thereof. Corresponding section was 173. Section 208, non-attendance in obedience to an order from the public servant. Corresponding section was 174. Section 209 of BNS is related to non-appearances in response to a proclamation under the section 84 of Bharatiya Nagrik Suraksha Sanhita 2023. Its corresponding section was 174A in IPC. Section 210, just give me a few seconds to drink water. Apology for this break. Pooja, increase temperature. 25. Section 210, omission to produce document or electronic record to public servant by person legally bound to produce it. Corresponding section was 175 in IPC. Section 211, omission to give notice or information to public servant by person legally bound to give it. Corresponding section was 176 in IPC. Section 212, furnishing false information, corresponding section was 177 in IPC. In BNS section 213, refusing oath or affirmation when duly required by public servant to make it, corresponding section was in BNS IPC 178. In BNS section 214, refusing to answer public servant authorized to question, corresponding section 179. Section 215 of BNS, refusing to sign statement, corresponding section was in IPC 180. In BNS section 216, false statement on oath or affirmation to public servant or persons authorized to administer an oath or affirmation, corresponding section was 181 in IPC. BNS section 217, false information with intent to cause public servant to use his lawful power to injury of another person. Its corresponding section was in IPC 182. In BNS section 218, resistant to taking of a property by lawful authority of a public servant, its corresponding section was in IPC 183. In section 219 of BNS, obstructing sale of property offered for sale by authority of public servant, corresponding section was 184. Section 220, illegal purchase or bid for property offered for sale by authority of public servant, its corresponding section was 185. In BNS section 221, obstructing public servant in discharge of public functions, its corresponding section was 186 in IPC. In BNS section 222, omission to assist public servant when bound by law to give assistance, corresponding section was 187 in IPC. In BNS section 223, disobedience of public duty, disobedience to order, public duty. Section 223, disobedience to order duly promulgated by public servant. Its corresponding section was in IPC 188. We have to complete 245. Okay. In BNS section 224, threat to injury to public servant, its corresponding section was 189 of BNS of IPC. In BNS section 225, threat of injury to induce person to refrain from applying for protection to public servant, corresponding section in IPC was 190. New section come into BNS which was not in IPC. That section is 226 section of BNS, attempt to commit suicide to compel or restrain exercise of lawful power. Attempt to commit suicide to compel or restrain exercise of lawful power. So, in front of collector office, somebody is pouring the rocket or petrol on oneself for malpractice or to be for inducing to public servant to exercise his power. So this is now offense under this section 226, attempt to commit suicide to compel or restrain exercise of lawful power. या कोई ऐसा बिल्डिंग तोड़ने के लिए आते हैं कोर्ट के ऑर्डर के अनुसार, फिर कोई अगर आके खड़ा हो जाता है सुसाइड कर, मैं if you are demolishing this building, then I will die like that. So that is called attempt to commit suicide. To compel or to restrain exercise of lawful power. Lawful power. After getting specific decree from the civil court, nobody have the right to stop that. But people are doing that. So for stopping that, this section is there. Chapter 14 of false evidence and offences against public justice. Earlier the chapter was 11 of false evidence and offences against public justice. Section 227, giving false evidence. Earlier section was 191 in IPC. Section 228, fabricating false evidence. Earlier section was 192 in IPC. In BNS section 229, punishment for false evidence. Earlier section was 192 in IPC. In BNS section 230, giving or fabricating false evidence with intent to procure conviction of capital offense. Corresponding section of IPC was 194. In BNS section 231, giving or fabricating false evidence with intent to procure conviction of offense punishable with imprisonment for life or imprisonment. Again, I am reading this. Section 131 of BNS, giving or fabricating false evidence with intent to procure conviction of offense punishable with imprisonment for life or imprisonment. Its corresponding section was in IPC 195. Section 232 of BNS, threatening any person to give false evidence. Corresponding section was 195A. Section 233, using evidence known to be false. Corresponding section was 196. Section 234, issuing or signing false certificate. Corresponding section was in IPC 197. Section 235 of BNS, using as true or true as using as a true a certificate known to be a false. Corresponding section was 198 in IPC. Section 236 of BNS, false statement made in declaration which is by law receivable as evidence. Corresponding section was 199 in IPC. BNS section 237, using as a true such a declaration knowing is to be a false. Corresponding section was 200 in IPC. Section 238, causing disappearance of evidence of offences or giving false information to screen offender. Corresponding section was 201. Section 239 related to intentional omission to give information to offense by person bound to inform. Its corresponding section was 202 in IPC. Section 240 of BNS, giving false information respecting an offense committed. Corresponding section in IPC was 203. Section 241 of BNS, destruction of document or electronic record to prevent its production as evidence. Corresponding section was 204 in IPC. Section 242, false personation for purpose of an act or proceeding in suit or prosecution. Corresponding section was 205 in IPC. Section 243, fraudulent removal or concealment of property to prevent its seizure or forfeited or in execution. Corresponding section was 206 of IPC. Section 244 of BNS, fraudulent claim to property to prevent its seizure as forfeited or its execution. Corresponding section was in IPC 207. Section 245, fraudulently suffering decree for sum not due. Corresponding section was in IPC 204. So friends, we have completed 245 sections of BNS, okay, here in this part 2. In part 3, we will complete the remaining balance section, which will be likely to be held on coming Tuesday. What date will be there? Tuesday? Coming Tuesday? 23, I think 23. 23 evening at 6 p.m. So that will last also 1.5 or 2 hours also. And after that, then we'll start a webinar on that BNSS compared to CRPC. We will complete that also. And then we will start webinar on my webinar on separate part of rape, separate part of murder, separate exemption, like that, such type of webinar I will conduct, so that in depth this basic law we should know. If you are I'm closing this, stopping screen share. Friends, so when law is perfectly enforceable by the society, the progress of that nation is very different. I just visited to South Korea 1 month, I think 2 months back, with my wife for 12 days. All Korea I have visited. Jeju, Busan, Seoul, and I travel all modes of transport, by air, by sea, by local train, best infrastructure. And South Korea was second developed country in the world. First developed country in the world is Japan, second is South Korea, third is USA, like that. What is the difference between a developed country and undeveloped country? Yeah, developing. We are a developing country. Some are our neighbor, maybe we can call undeveloped countries. But we are developing. But there is vast difference between developing and developed countries. What a law and order in South Korea I find perfect. At night 3 a.m. also, people, car drivers, four-wheeler drivers are maintaining the signals of zebra crossing also. Nobody is crossing zebra on zebra crossing. No human being is crossing that. But even though signal is there, they are stopping there. Full road infrastructure, everything is the best. I'm not only admiring them. My intention is my India should be on that position. And in that, our role is very important as a lawyer. So I'm going on that point. I know that my commitment with you only for 1 hour, and I'm taking that time. You may be hungry. Saturday, relaxed day. Our registry is working on Saturday also, Supreme Court registry, but argument is not there. Judges are also working. I will come on that point. So what is exactly judiciary? What is exactly police? What is exactly infrastructure we have? What improvement we need? What practical things we should focus? And who are responsible for that when any wrong is done? So friends, I saw in South Korea. Next year, I will go to Japan also. And I will stay in Japan for at least 15 days to understand where. Buddhism, everywhere is Buddhism. Gautam Buddha is there. Whole country is Buddhism. But what infrastructure they have? If building construction is there, building construction is there, but that is completely closed. You cannot see the construction is going on. Otherwise, in our country, every day road are digging for cables, for gas pipe, then some for pipeline and nobody is repairing that. Everywhere wiring. If you come to Delhi, you will find everywhere is wiring. But I have not found a single wire on the road. Poles are there, electricity is there. Not a single minute electricity gone in rural area also. This is because of law and order and because of education. So, these two people's role is very important. Teachers, quality education. And as a lawyer and as a police officers, it is our duty to implement law properly in positive way, not to grab money only. And judiciary should act very fast disposal. Some judges are very fast in session court also, in district court also, in civil court also, in high court also, in Supreme Court also. But some are exceptions for that. It should not happen. Now judiciary is facing a larger burden. If I am telling about my court, Supreme Court, judges are working at least every day, at least 16 hours. You will find on bench they are sitting from 10:30 to 4. Maybe 1 hour or half hour they are taking for lunch. But apart from sitting on bench, before sitting on bench to read the properly that board's matters, come with proper study. So they are in court around 9 a.m. Some maybe earlier also. And after completing bench sitting, they have to complete their judgments. Sometimes on Saturday and Sunday also they are coming to the court. And they have their separate offices at their residences also. Full-fledged offices they have. They are dictating, they are typing. Most busiest person in legal fraternity is my Supreme Court judge. Busiest. Same way we will find High Court judges also. Near about all judges of High Court and Supreme Court are dedicated every day 15 to 16 hours. Then as a lawyer, we should also dedicate some time. And we should help to judiciary for proper adjudication. Maybe in our client's favor, if our client is correct, in favor. If our client is wrong, judges will decide whether he is wrong or right. Our duty is to produce proper documents before the judge, and without doing any confusion and without giving litigation let, we have to conclude the litigation as early as possible. After winning the case in labor court, people are finding the result after 15 years. This is the very bad side of our judiciary, our legal practice. Because of appeal, after getting decree also in the execution, people are finding the ways to avoid that execution. After getting the punishment of death sentence, with the consent of High Court, Session Court is giving the death sentence, and to implement that sentence, we are finding the ways. So somewhere we have to change this. 1 appeal, 2 appeal, that should be sufficient. Appeal. Only persons who have the money, they can do that. The person who don't have money are not facing it. I know. Legal aid system is there. NALSA is there to protect them. Constitution directive principle of state policy is given. Compulsory legal assistance is given, like health, like education. Constitution has provided so many things. But to implement that, It is in our hand. So whenever, as a lawyer, whenever you go to from nearby any police station, just go and enter in police station. This is my habit. I'm going to that police station. I'm meeting to constable. How are you? I'm a Jayprakash Somani. I'm practicing in Supreme Court of India. Just I come across from this police station. Just I want to see what problem you are facing. I'm asking them what problem you are facing. I want to meet you in charge. Then I'm meeting to in charge also. They are offering me tea. They are offering me breakfast also sometimes. They are discussing with me very fairly. Whenever they need my help, they are calling me also. They are taking my help also. So this is our, not only for a matter, go in police station and ask police station, send me matter. No, friends. Don't solicit that type of matters. You will ruin your image. Matter automatically आता है भाई. मैंने now I am running in 60s. लेकिन मैंने जब प्रैक्टिस स्टार्ट किया था ना 1989 में, तब से आज तक मैंने पैसे के पीछे कभी नहीं मांगा. नेवर. पैसा अपने आप आता जाता है. Excellency, you put your excellency in legal practice. ठीक है, आप इंग्लिश में वीक हो सकते हैं, आप किसी लैंग्वेज में वीक हो सकते हैं, लेकिन अंदर से मजबूत अगर आप है ना, तो लैंग्वेज मेक्स नो difference, because judges are also from vernacular languages. They don't expect a fluent English from you. In case of High Court and Supreme Court argument, I am talking about. But when you are arguing in trial court is you are arguing in your local language also. So proper study, proper focus to give the justice to the justice and timely justice to our client is very important. And when that happens, then when police department is doing their duty, when parliament people are doing their duty fairly, when Vidhan Sabha, Vidhan Parishad people are doing, assembly are doing their duty properly, we are doing the properly, teacher are doing the properly, that time our nation will be a developed country. And our infrastructure should be more than good than this developed country. Because we have the tradition of Acharya Chanakya. We are the Vanshas of Acharya Chanakya. Chandragupta Maurya. In that era, how our Hindustan was big. And how all kingdoms are under one umbrella. Now we are under one umbrella. All states or union territory under one umbrella. Very good system. Its government is doing a very nicely things. Earlier government was also doing nice things. This government is also doing nice things. Every government is putting their best. But as a citizen also, our duty to give the proper voting. So in every webinar, at last some minutes, I will share my views with you. Because whatever age I have, I don't know. Whatever age Lord Krishna has given, I don't know. But I am thinking to be a fit for more than 100 years. Daily, without any day break, I am doing my regular exercise. No Sunday break also. Daily exercise, regular. Walk, exercise properly. No headache, no temperature, no BP, no sugar. I don't have any disease because of this exercise and because of the blessing of my Maharashtra's Panduranga Lord Sri Krishna. And I will not get retired from practice. No. Death will get my retirement. Death will cause the retirement. So I will put whatever value addition for my nation, for international level, whatever value addition, whether I am putting. Similarly, I am requesting you all. We are in a very noble profession. We have a very great chance to improve our country, to improve our law system, to improve our judiciary, to improve everything. Whatever contribution you will get chance to contribute, just go ahead and do that. Sometime we have to take the less fee also from poor person will not give us our regular fees, but we have to adjust that. So this is the part of our contribution. Thank you very much for attending. Manoj, are you there? Manoj. Just let me ask Manoj. Manoj, are you there?
Yes, sir.
Conclude now.
Yeah. Thank you all the participants for attending this part 2 webinar for the comparison of BNS versus IPC. Thank you. We'll have a part 3 on 23rd of July at 6 to 7.
6 to 7:30 or maybe 8.
Yeah, 6 to 7:30. Thank you very much, sir. Thank you.